Goeienaand, good evening, fellow South Africans and citizens of the world. And in this video, we're going to be talking about basically black economic empowerment and why it is the same as black privilege, which is the exclusive domain of very well-placed ANC politicians and other major parties like the EFF, their cadres, their families, their friends, while the rest of the black population are just getting poorer and poorer and poorer. This is the hypocrisy of South Africa's democracy under the ANC government. And it's a classic David and Goliath case, because the David in this case is actually a major insurance company called Old Mutual. And they're taking on one of the black beneficiaries of BEE. And I'll spell it out to you so you know exactly what's happened in this case. And you'll see how corrupted the whole racist system under the ANC government is. And this is just one element. Old Mutual has emerged victorious in its 7-month battle with axed CEO Peter Moyo, with the Johannesburg High Court paving the way for South Africa's second largest life insurer to not reinstate him and to start a process to replace him with a permanent leader. On Tuesday, the 14th of January 2020, the court upheld Old Mutual's application to appeal against a 30 July 2019 ruling by Judge Brian Mashili that ordered the temporary reinstatement of Moyo as CEO and blocked the insurer from appointing his successor. A full bench of judges, Peter Meyer, Rayleigh Cately, and Keogili Matiani, set aside Mashili's ruling, finding that the dismissal of Moyo by Old Mutual was lawful and did not flout causes of his employment contract with the insurer. The ruling affirmed Old Mutual's right as an employer to dismiss an employee that it is accused of gross misconduct and believes its relationship with them has broken down irreparably. However, Moyo plans to fight back, as his lawyer Eric Mabuza wrote a letter to Old Mutual, informing it that the axed CEO intends to petition the Supreme Court of Appeal, or SCA, to challenge the ruling. Mabuza said the legal implications of Moyo's pending challenge at the SCA means the earlier ruling, which temporarily reinstated him as CEO, remains valid and operational. Mabuza said Moyo will still forge ahead with another lawsuit against Old Mutual, called Part B, wherein he wants the insurer's 14-member board, including board chair Trevor Manuel, to be declared delinquent under the Companies Act. In this lawsuit, Moyo is claiming contractual and reputational damages from Old Mutual amounting to 250 million rand. Business Maverick understands that Old Mutual is prepared to fight against any further legal action to be launched by Moyo, including the SCA petition. This adds another twist to the protracted corporate warfare between both parties that has weighed on Old Mutual's share price, which has fallen by 9.3% since Moyo was suspended on the 23rd of May 2019, on the grounds of material breakdown in the relationship of trust and confidence, and dismissed on 18th of June 2019. The drop means that 9.7 billion rand has been wiped off Old Mutual's market capitalization to date. The battle has also overshadowed the life insurer's homecoming, with 2019 marking a year since it moved its primary listing and headquarters to South Africa from London after 19 years. Well, that was a bad move. The ruling will likely appease Old Mutual's second largest institutional shareholder, Alan Gray, with a more than 9% shareholding, which recently said it hoped the courts rule in the insurer's favour, and for Moyo to leave without a financial statement. Moyo, who is visibly disappointed by Old Mutual's victory, was also slapped with a cost order as he has to pay the legal fees of two of the insurers and Manual's senior counsel. Moyo also has to foot the legal bill for two senior counsels representing Old Mutual's 14 non-executive directors. Old Mutual spokesperson Tabi Tsangiwe said the latest ruling vindicates the insurer for its decision to fire Moyo. The judgment provides legal clarity on corporate governance and board stewardship, including the relationship between the board and its executive leadership, in this instance, the CEO of the company, she said. Tsangiwe added that Old Mutual's latest court victory means that its board is now free to start the search for a permanent CEO. Old Mutual has been without a permanent CEO for 7 months, with Ian Williamson holding the fort since Moyo was fired. To recap, now this is where we get to the nitty-gritty. To recap, Moyo was fired for allegedly pocketing dividend payments worth 30.6 million rand linked to an investment holding firm he co-founded called NMT Capital, in which Old Mutual has a 20% stake, which it acquired in 2005 as part of a black economic empowerment deal. This is how they are stripping assets out of companies that they are only there because of BEE. So Old Mutual needed this association to be BEE compliant. That's the bottom line. And this is how they defraud these companies that are basically beholden to doing this sort of stuff to be BEE compliant. Anyway, let's hear what happens here. Okay, let me just repeat this to recap. Moyo was fired for allegedly pocketing dividend payments worth 30.6 million rand linked to an investment holding firm he co-founded called NMT Capital, in which Old Mutual has a 20% stake, which it acquired in 2005 as part of a black economic empowerment deal. Moyo chaired an NMT Capital meeting on the 4th of July 2018, where he allegedly declared an ordinary dividend worth 105 million rand and allegedly paid himself dividends, even though Old Mutual's preference share dividends had not been paid. Moyo's case has been about how he was dismissed in terms of his employment contract, arguing that he was entitled to a disciplinary hearing first, even though Old Mutual terminated his contract on 6 months' notice with pay of 4 million rand for the entire period. In other words, he chose to fight Old Mutual on contractual grounds rather than unfair dismissal under the Labour Relations Act, or LRA. Why did the court rule in Old Mutual's favour? The first High Court ruling delivered by Mashili found that Moyo should be temporarily reinstated pending Part B of his lawsuit because the insurer didn't offer him a disciplinary or pre-dismissal arbitration hearing in terms of Clause 24.1.1 of his employment contract. However, Meyer disagreed with Mashili's approach. Meyer wrote in his ruling, concurred by Cately and Matajani, that Mashili wrongly viewed Moyo's case through a labour law prism, in the sense that Old Mutual treated Moyo unfairly when it fired him on 6 months' notice and without a disciplinary hearing, even though Moyo didn't rely on the LRA. Meyer said, adding that a clause of fairness and a right to disciplinary hearing are not incorporated in Moyo's contract with Old Mutual, by saying, however, there is no such self-standing common law right to fairness in employment contracts. A right to be treated fairly when a contract is terminated only exists if it is expressly or impliedly incorporated in the contract. Meyer said Moyo's employment contract must be read together with Clause 24.1, dealing with his contract being valid for a limited period until his retirement age of 60. He is currently 57, but can be terminated by either party with or without a 6 months' notice, or on grounds valid under the LRA. Clause 24.2, which gives Old Mutual the right to terminate Moyo's contract if he is found to be guilty of misconduct, which would entitle Old Mutual to dismiss him. And clause 25.1, dealing with Old Mutual being entitled, within its sole discretion, to decide whether or not to hold an internal disciplinary inquiry or to proceed instead via a pre-dismissal arbitration procedure under the LRA. Moyo argued that clause 25.1 affords him a contractual right to a disciplinary hearing, and that Old Mutual was obligated to subject him to a hearing when he was accused of misconduct. This was affirmed by Mashili. However, Moyo said that the clause gives Old Mutual alone the discretion and not an obligation to hold a disciplinary hearing. It said Moyo's interpretation would lead to the absurdity and unbusinesslike result where the employer would be obliged in every instance where the allegation of misconduct had been raised against the executive to hold either an internal disciplinary inquiry or pre-dismissal arbitration, even though the employer, for reasons of its own, does not wish to pursue the matter any further or take disciplinary action. So, central to this whole action, and you can see the charade that's now going on with this guy who is fired, central to the whole thing is the fruits of black economic empowerment and how the black privileged amongst the black community, a tiny, tiny percentage of the black African population, are just cleaning out the till. This guy got caught. All right, guy, please remember to subscribe, to be kept informed, ring the bell, please like this video, please share this video, and above all, stay safe. Bye for now.